All right, welcome back. Yes, indeed, that is what we're focusing on this morning. We've got Mr. Ebonlu Adegborowa, Senior Advocate of Nigeria. Good morning, and thank you for joining us today. Well, it does appear as if it's a critical time now, almost in different sectors of the country, economy, extension. Judiciary workers, now they've down tools, and that is definitely going to affect the system in spite of all the appeals. Well, I haven't seen the way this is playing out. Was this something you saw coming, or perhaps given those interventions, you might have thought, okay, well, maybe there just might be a way out without them having to go on strike?
Thank you very much. Good morning. I believe that the general thinking in Nigeria is that the best language that the executive understands is a kind of force and by way of strike action. You recall now that virtually all sectors of this country is on strike. Doctors are on strike. Lecturers are on strike. Electricity workers have been on strike. National Assembly workers have been on strike. So even at a particular time, security agencies, police force, policemen went on strike. In this particular case, a notice had been issued by members of the Judicial Workers Staff Union of Nigeria since March 13, which I believe was sufficient time for government to embark upon dialogue and negotiations towards ensuring the implementation of the Constitution. And why do I say this? You know, we don't need this strike at all, because the law is very clear that Nigeria shall be run as a federation. And that federation consists mainly 3 tiers of government in Section 4, establishing the legislature, Section 5, establishing the executive, and Section 6, establishing the judiciary. These 3 organs of government are supposed to be separate and interrelated, operating the theory of separation of powers and checks and balances to ensure independence and autonomy for the arms. Presently, the executive is the only arm of government that is independent because, as you well know, the executive is in charge of appropriation and revenue. But, of course, during the last National Assembly, they fought that battle and they were able to also gain their own independence to the extent that they now have a National Assembly Commission and they are in charge of their own funds. So we are left with the judiciary. And I think it's important to understand what we mean by agitating for legislative, judicial autonomy. The Constitution provides clearly that Nigeria will have what we call Consolidated Revenue Fund in Section 80, 81 to 84 for the Federation. Now, you can take money from that Consolidated Revenue Fund only in 2 ways. The money that is charged as first line on that fund, you can take it directly from that Consolidated Revenue Fund. Secondly, money that is appropriated as contained in a budget estimate by the executive. Once it's approved by the legislature, you can take money from there. Now, if you look at our experience, the Independent National Electoral Commission, INEC, the legislature, National Assembly and the state assemblies of the states, and the judiciary, their fund and revenue are on the first line charge of the Revenue Consolidated Fund. In other words, they don't need to go through appropriation in order to ensure their independence. So you see that in this last year or so, the chairman of INEC took the budget of INEC directly to the National Assembly for approval. He didn't have to go to the president. He didn't have to go to the Minister of Finance, because you have to ensure the independence of INEC, being the body conducting an election. You can imagine the chairman of INEC going to meet president to get money. That will compromise him. So it's in that same spirit that it's expected that the judiciary will take its own budget directly to the assembly for approval.
Is this a brainer? Why is it an issue?
It's an issue because, you know, from our experience, the executive is unwilling to allow the judiciary to become independent. And I will explain the reasons why. You know, when you talk about implementing decisions of the judiciary, it affects mostly the executive. because the executive is in charge of executing and implementing policies, taking people's land. For instance, the police is a branch of the executive, arresting and locking people up. And these are things that go to the regular courts for implementation. And so if the judiciary is independent, it becomes a check on the excesses and impunity of the executive. That's why you see that it's difficult for the executive to allow the judiciary have its own autonomy in order to continue to reign in impunity and breach of the law in most cases. So that's why we've had this challenge, because the executive is unwilling to follow due process.
Stopped the courts from pronouncing judgments. If you look back, even down through our history, even during military eras, the judiciary was always standing. Well, maybe not completely independent, but they were always standing. And then we didn't have a National Assembly most of the time during any military interregnum. But it's been 20 years, going to 21 years into this Fourth Republic. And I believe that some of the people, if not most of the people who are in government today, fought to be in this, for a Fourth Republic, for democracy to return. Now democracy has returned. What could be holding them back, the politicians now, whether they're in the executive or in the legislature, from doing what needs to be done? It's the Constitution. It's the ground norm of the country.
Well, as you can see, if you follow the trend, the judiciary has been complaining that once they have to go cap in hand to beg for fund, it constitutes a limitation on independence and autonomy. And I'll just give you an instance. It was said of a particular chief judge of a state who had a case in her court relating to an action of the state of that particular state of the federation. And one day she went to see the governor to be able to get approval for certain items and request approval for funding. And jokingly, the governor said, my lord, we understand that you're about to give judgment against us, And so you see what that means for an institution that is supposed to be the last hope of the common man. If you have a case before a judge against a governor, for instance, and that judge has to go and beg the governor for funds to pay salaries, it will surely affect her mentality. In going to that same governor when you know you have a case to decide against the governor. And it was a shock to us when we got to the NBA conference 2 years ago, and we were debating this issue on the consequence of withholding autonomy for the judiciary. And some lawyers say that, look, just like you said, judges are always free to take decisions and that there's nobody holding them. The chief judge of Edo State, I believe she's now retired, came out during that conference and said, look, it is not so. He who pays the piper dictates the tune. And she said openly that judges are not able to exercise their free will if they know that they have some hindrance in getting their funds from the executive. And I think the President CJN said it on the day we were conferred with award of senior advocate at the Supreme Court, that the issue of checks and balances in the Constitution is not being achieved because there's a limitation to the autonomy for funding for the judiciary. So I think that this matter should be settled because a judgment has been delivered in the case of Agbakoba in 2014. Another judgment has been delivered in the case of judicial workers, mandating both the federal and state executive to release the money for the judiciary. And I must state here that I commend President Buhari unusually for his bold initiative towards achieving this autonomy.
If I could follow up on that, because when you say the executive is unwilling, but he then signed the Executive Order 10. So isn't that demonstration of intent that, look, we're willing to change these things? It's now up to the state executives to actualize this.
I think the point we should make is that there are divided opinion on the constitutional power of the president to sign Executive Order 10 in relation to funding, especially for the state houses of assembly and the judiciary. I believe, with all due respect, that when you read section 80, 81, and in particular 84, of the Constitution, it becomes clear that we don't need Executive Order 10. What the president has done, which we must commend him for, is to sign into law the fourth alteration, which amended Section 121 sub 3 of the Constitution. And the president amended it, assigned to that bill that was passed by the last National Assembly to say the money that is meant for the heads of agencies mentioned in Section 121, especially the Judiciary, should be paid directly to an account nominated by the head of those courts. If that is a law in Nigeria, and the fourth rotation is already a law in this country, we don't need any Executive Order 10. It's for us to appeal to the governors, especially to be able to have the courage to allow democracy to work, so that the judiciary will have control of their own fund. The only thing that will be subject of appropriation will be capital projects. You want to build a court. But to buy cars for judges and then line the cars up and then call judges and be handing over keys to them in a democracy, it's not supposed to be so. It's not supposed to be so. The salary of a judge is supposed to be assured. It's not supposed to be altered. It's not supposed to be at the whims and caprice of the executive, because the Constitution is clear that he must be on the first line charge of the Consolidated Revenue Fund. That budget should be under the control of the judiciary.
Okay, let's take this to Mr. Kehinde Shobowale, who's the chairman, Judiciary Staff Union of Nigeria, Lagos branch. He also joins us here in Lagos. Good morning, and thank you for joining us. I know you've been following the conversation, and you're at the forefront of this fight to ensure financial autonomy, in fact, autonomy generally for the judiciary. So, Mr. Adegboruwa is of the opinion that, you know what, the executive has been unwilling, and we've tried to find out, is it at the federal level, at the states level? But as a starter for you, really, having followed this conversation in light of what you're fighting for, what message are you trying to pass across to the government? Mr. Shobowale, I believe you can hear me.
Yes, I can hear you now.
Okay, please go ahead.
Can you hear me?
Yes, I can, loud and clear.
Well, I can't hear you again.
Okay. Well, I can hear you. If you can hear me, you could just go ahead with your response. Okay, let me just take the question again. But first, can you hear me? Okay, we'll work on that. But let me come back to Mr. Adegboruwa. Trying to understand who, should I say, the villain is here, because it's quite tricky, but we need to identify where the challenge is. The president has signed the executive order. In fact, the order mandates the Accountant General of the Federation to deduct from source the amount due to state legislatures who, fail to, abide by that provision of the Constitution. So is it at the federal, at the state, or both of them share this culpability in some sense?
I think generally we must compartmentalize the level of breach of the Constitution between the federal and the state governments. Like I said earlier, it's a commendable act on the part of the president and the last National Assembly for passing the fourth alteration amendment of the Constitution by giving directive that money be paid directly to the accounts of those agencies. But I think the federal government itself is still in breach, because in the last experience, when the president approached the National Assembly, the budget of the judiciary was still within the appropriation bill, which was surrendered to the National Assembly. And this ought not to be so. So to that extent, you will see that in the federal courts, Supreme Court, Court of Appeal, the Federal High Court, National Industrial Court, there is some level of autonomy in terms of their finances, in terms of the control by the heads of those courts, of the salaries in particular, and the remunerations and other things that require financial autonomy. But the problem mainly is within the states. And this is why I lay it at the feet of the governors, that we need to appeal to them. And that's what has led to this strike. The governors do not agree that the chief judge of the various states should have control of their funds. And they are not agreeing because it's a means of controlling the executive. It's a means of more or less exercising some kind of influence upon the activities of the judiciary, which is not acceptable to us. So to that extent, I believe JUSUN should have some kind of discretion in the way this particular strike is implemented. Because as of today, I verily believe that the federal courts are enjoying some level of autonomy in terms of their finances. The battle should go to the doorposts of the governors of the various states, because those are the areas where we have challenges, where the chief judges of those states are not allowed direct control of their funding.
Well, speaking of JUSUN, let's try Mr. Shobowale again and ask if this is the game plan of JUSUN in trying to achieve autonomy. Well, Mr. Shobowale, if you can hear me, please go ahead.
I can hear you. For us in JUSUN, we felt that it is time. It is time for the judiciary to move forward. Now, this battle has been with JUSUN for a very long time. If you remember, we went on strike in 2014 for the same cause. If you also remember, we went to court. We have a court judgment, and the court judgment was sacrosanct. This thing is easy. I don't know why the government does not want the judiciary to be free. Now, for us in JUSUN at the national level, we felt that an independent judiciary is the best place for us to work, is the best place for us to give our best, is the best place for us to make sure that the court still remains the last hope of the common man. Now, for us, this strike is our last resort. I was at the last neck, and all avenue, all effort has been made. And it seems the government is so adamant in allowing judiciary to be free for whatever reason best known to them. But for us in JUSUN, we felt this is the time for us to do this thing, and this is a time for us to make sure that the judiciary is totally independent. Thank you.
So, leaning on that expression, he who pays the piper dictates the tune, for me, I imagine that speaks a lot about the kind of influence that the executive will have on the judiciary. So if you could tell us, to what extent really is that influence? Because we could look at judgments and start casting them in the light of, so maybe, just maybe, the executive had a hand in this judgment. Is it really that bad?
For us, for us in Lagos State, let me say this. For us in Lagos State, I don't think the government has hand in any judgment that has ever come out of Lagos State. Because I know that the judges in Lagos State has this, what we call integrity. It's a superb integrity. And they avoid so much influence that has to come from the government. But you see, at times, when he will pay the piper, you know what it does. If my CJ has to go camp in hand to the government, to the governor every time for approval to do even the simplest thing as staff allowances, even the simplest thing as utility vehicle for the judiciary, then you should know how it's going to be a little bit difficult for the running of the judiciary, for the smooth running of the judiciary. But for me, from my own perspective, I don't think the government has any hand in or any influence in any judgment that has come out of judiciary.
Well, you know that the NBA did appeal to JUSUN to shelve the strike, saying the timing was wrong. Even the CJN also waded in. So it appears those fell on deaf ears. Why was that?
Can you take the question again, please?
The NBA appealed to JUSUN to shelve the strike in the interest of public and that the timing was wrong. But JUSUN did adhere to that. Why?
The timing, the NBA is saying something about timing. For us in JUSUN, which time is right? Timing of going to strike. Well, I felt the NBA should even be at the forefront of this fight because we have the bar, we have the bench, We, the staff of judiciary, are just the middle carrier, the carrier of justice. We implement whatever they spill out. We are in the middle of the bar and the bench. And I feel the bar, especially the MBA, should be at the forefront of this fight. So telling us that the timing is wrong or the timing is not right is not tenable. Now, the CGN, I sympathize with the CGN, but I know that my national leader in Abuja, the NEC, I'm sure they are in good consultation with the CGN, and I'm sure decision will be made soon. But for us in Lagos State, we are following the national strike that close all gates to the court, all gates to the court will be closed.
Yeah, but Mr. Adegberowa, could you help us shed light on that? I mean, what's the NBA, because he said, we thought they're supposed to be on the same page, even the CJN. What's going on?
Yeah, thank you very much. This particular strike of judiciary workers is actually on behalf of lawyers and judges and on behalf of Nigeria. Because, and I say this with all due respect, when you look at the function of the judiciary to the existence of this country, right from the creation of Nigeria, the judiciary has been the only arm of government that is not subject to change. The military will come, sack civilian government. The judiciary has been the only chain of continuity. And that's why you have not seen any military government that has come to sack the entire courts. And so to that extent, you shouldn't allow such body to become starved of fund to the extent that when you go to some courts today, you cannot even sit down. If you go to Ikoyi and check the Federal High Court in Lagos, it's been under construction maybe for the past 10 years on body lawn. And we have such small cubicles where lawyers stand outside and they are calling them only in turn when they have their cases to be heard. This shouldn't be. So to that extent, I believe that the Nigerian Bar Association actually should follow its own motto, which is the rule of law, and ensure that any organ that is championing the cause of that rule of law by ensuring independence and autonomy of the judiciary is supported. So to that extent, I think it's just a matter of implementation. The NBA has always been in support of efforts to guarantee independence for the judiciary. So the appeal of the NBA president is only for the timing, not that we do not support the strike at all.
Also wonders then, Mr. Adegberowa, why it has taken this long for the NBA to even say a thing. I mean, just as you heard, I mean, as you're well aware, there have been judgments before now. To compel, you have quoted at least 2 of them here today. And if you, just as you say, if this strike is in the interest of the Nigerian Bar Association, one would wonder why it would seem like the NBA has been quiet until now.
Well, you know that in order to avoid the pitfalls that we suffer in the hands of professional politicians in Nigeria, lawyers met and decided that we should limit the tenure of our president to 2 years. You know, and so to that extent, I think that issue of continuity, it has been a challenge for us in terms of enforcing the judgments in respect of judicial autonomy. So, you know, when the president comes into office, he has only 2 years, so he has to prioritize what probably will be his own goal in terms of achievement. But at the National Executive Council of the Nigerian Bar Association, which is a standing, the highest standing organ of the body, we've always taken the position that we support judicial independence and judicial autonomy. But to declare a strike is not within the power of lawyers generally, because we are not in control of the court system. So that's why we are supporting JUSUN, because they are the workers who can actually implement that strike. Lawyers are in private practice, so it is difficult to, for instance, enforce such strike, you know, across board. But a body like this, you know, being the ones directly in charge of implementing policies of the judiciary, are in the best position to do that, and we support them fully.
But Mr. Shumwale, now that we have this on our hands, you have said that there have been previous judgments, that you have gone on strike before, and this has not been done by the various governors. What's the assurance that this time around there will be a shift?
Well, we believe that 2014 is different from 2021. We also believe that this time around, even in the public view, everybody wants independence for judiciary. And that's why we are calling on all stakeholders, everybody, to rise up now and support Judiciary Staff Union of Nigeria in achieving this feat. Once the judiciary is free,
yes, just a quick one.
Everybody can come to the court and get judgment.
Just a quick one, Mr. Shibowale, before you go.
What is different now? Let me say this.
Just a quick one. Have there been any conversation with any governor? Have you had any interface with any governor to the effect that you want this action taken by them?
Right now, we've not had any discussion with any government agency. In fact, we are not even allowed to have any discussion with any government agency except with our national. It is only the national body that has a mandate to speak with any governor over this strike. My instruction is to close the gate and wait for further directive.
All right, then, what a time to close the gate. Well, we do thank you for your time this morning, Mr. Kehinde Shibowale, Chairman, Judiciary Staff Union of Nigeria, Lagos Branch. But we will be back in a moment. Don't go away. All right, welcome back. Just one more thing on this judiciary workers' strike, Mr. Adegborowa. Does that then mean that the decision to limit the tenure of the NBA presidency to 2 years, given that they had to prioritize, and as such, they've not been able to make this one the main issue for some time, is that decision hurting the NBA in that regard?
No, not necessarily. It helped us to achieve smooth succession in terms of the rancor we normally witness during our elections. Because our organization is zoned into north, south, west, and so we produce leaders in that order. And it's always a tenured election of just 2 years. So you don't dream of second tenure and then the normal problems of continuity, trying to force yourself to be in office forever. And that has helped us indeed. But I just wanted to make a point that the issue of autonomy for the judiciary has been achieved by some states. I'm aware that Bayelsa State, Delta State, and probably some other states have passed their own local laws within their own state, authorizing that money be paid directly to the purse of the judiciary of those states. And I think I also need to advise Jusun, if I can, that you should take this strike holistically, so that you don't achieve autonomy for the judiciary and then you come back to face the issue of corruption within the system. We come back to face the issue of lack of infrastructure, which is hindering effective administration of justice. Yeah. Judges writing in long hands, the infrastructure is poor, there's no power supply. So Jusun should just take it holistically so that when money is eventually released, they can monitor the money and police it and ensure that it's used for the right purpose and it's not subject to the normal Nigerian problems.
All right, so let's move on to the NSAS panel. So could you give us, what is the progress report? Because there's been several inquiries about, okay, now that compensations are going on in different parts of the country, what becomes of the ultimate recommendation? Will the federal government have to set up another panel to look into all of those things? Will they address any issues? Are the issues been so many? So just start from that. What is going on at the moment? Any progress being made?
Oh, yes. Thank you. I must tell you that a lot of work is going on within the panel in terms of hearing the petitions. If you look at the history of the panel, its establishment is a product of the 5-for-5 demand of the NSAS protesters. And we came into being sometimes in October, and by 20th of this month, it will be 6 months, we had about 230 petitions as of December, And by now, we have heard over 70 of those petitions, some of them concluded, judgments delivered, and compensation awarded. You know, the unique thing about the judicial panel on NSAS is that you don't get judgment and then it becomes empty. Once we have found that there is human rights abuse that is worthy of compensation, the fund is available already for us to issue check immediately and pay. So there's no process of appeal, there's no process of going to file application for execution of judgment. And so far, I believe that, you know, a lot has been achieved, you know, by giving people opportunity to pour out their mind, even though we didn't know the depth of the kind of problems citizens were facing in the hands of law enforcement agencies. But when we listen to these stories, people who were executed, people who have been maimed, people who have been denied of their rights or subject to torture or abuses, it's quite very mind-boggling. But I believe that so far, we have been able to address substantially the grievances of some of the petitioners that we have listened to.
If I could just jump in there before you go further. But we have equally heard some persons who have said, well, yes, some compensation has been given them, but they just felt it wasn't commensurate with what they have gone through.
Well, generally, I don't think, honestly, that any amount of money can compensate torture or deprivation. I mean, if you use myself as an example, I mean, in the period of Abacha's reign in this country, when we were arrested from November 1996 and kept in underground cell till July 1997. So what do you pay me to compensate for asking me to be looking at the sun every day, or torturing or denying us access? So what we do is important for us to, first of all, listen to people. Let them pour out their heart. Let there be a healing process. And then be able to get the respondents, especially the police and those other security agencies, to come to defend or even listen, you know, to the complaints of people, so that in that course, there will be a need for us to avoid a repeat of those kind of experience. So it's not just a matter of paying monetary compensation. It's to listen to people, to pour out their hearts, and then make recommendations to government that will enable the institutions concerned to make amends in that regard. And I must tell you, presently, we are about to enjoy a 3 months extension in terms of tenure. But if you look at the regular courts in Lagos State, it takes average 4 years or more for you to conclude the case to hearing, to judgment. But we have been able to reduce that and ensure that we take away all technicalities and allow people. So I think that even 1 year may be insufficient to address over 230 petitions. And people sitting every day, especially the chairperson, Honorable Justice Doris Okuobi, you know, at her age, coming from the mainland and sitting every day, you know, listening to petitions, listening to witnesses, lawyers. I must say it's been quite a wonderful experience. And I commend the government for setting up the panel. And I can assure you that we have total independence. Nobody, for instance, will be able to think that I will listen to any advice or control. So we meet and decide cases, you know, on our own terms, based on our conviction, based on what we see and hear from the witnesses. And it's quite a very wonderful experience. But the other thing I would like to say is that we can't conclude, especially in respect of Lekki matters, whether death occurred or death didn't occur. The investigation is ongoing. We are listening to doctors. We are listening to complainants. We are listening to respondents. We are listening to the army. So until we come to a period when we have concluded the hearings, and then we assess them, and then be able to make up our mind whether indeed it is the case or it's not the case. So I say that, and I say this with respect to the report of the American U.S. Embassy in terms of the human rights report on Nigeria. I think it's too early to conclude whether there was anything at Lekki Toll Gate or not, until we have been able to exhaust our hearing and listen to all the witnesses before we come to a conclusion.
You know, I will shed more light on that report in a moment, but it's interesting to see that this issue of autonomy follows the judiciary almost everywhere. Even with the panel, there's questions about autonomy because, I mean, the panel is basically funded by the state. The monies was given out, was allocated by the state. So I think it might be also good to further shed more light on that and just how that is not going to be a hindrance in dispensing justice on this panel, because that has been a major topic.
I think the panel could be used as a model for the independence of the judiciary that we talk about. Because before we commenced, I in particular, with other members, especially our chairperson, insisted that we wanted an independent secretariat, that we will be in charge and in control of. We wanted an account, that the money meant for the running of the panel and other issues are not subject to further approval. And we got that. Even though some of us are working there pro bono and without payment, but I ensured with the cooperation of the chairperson and other distinguished members of the panel that the funding for the panel had been available ahead of inauguration. And so we didn't agree to sit until those issues were sorted out. And I can assure you today as I sit, the panel is totally independent, both financially and in terms of administrative structure.
When you talk about using the panel as a model, the question that comes to my mind is, well, the panel is not handling political cases. So to what extent can we use the panel as a model in that regard?
No, what I mean by model is, for instance, when you come to a conclusion as a judge that something is wrong and you issue out a judgment, that judgment should not just be on paper. It should translate into something beneficial to the person who has approached the court for redress. And that's what we do in the panel, to say, once we convince ourselves that there is a particular grievance that needs to be remedied, we go ahead and issue a check for that and pay immediately. So we must get the National Assembly to ensure that the judgment enforcement procedure rules, which is an inheritance from the colonialists, is amended in such a way that judgments that have been delivered by the regular courts can be implemented immediately. So you don't need to subject it to the approval of the executive through the Attorney General before you get your money, for instance. Those are things that we don't face in the panel.
If you could just also clear this one, because we've seen a trend. Policemen whose names have been mentioned in cases fail to appear time and again. And for some, they wonder if that might hamper the outcome of this panel. So in that regard, haven't seen the trend, and it would seem that this trend might continue up until the termination of the panels across the state. Will that in any way affect the outcome?
I think there's not been proper reporting of events going on at the panel. Without wanting to mention specific petitions which are still pending, I must, with all due respect, commend the Nigerian police in particular, because the police assigned 4 lawyers to the panel who attend the panel faithfully and regularly. And once the panel issues out summons to particular policemen, they always appear. I have sat in the panel and listened to not less than 5 different police officers who have been summoned by the panel to come and defend certain allegations, and they have been there. So it's for us to make up our mind whether we believe them or we don't believe, but it's not correct that policemen who have been summoned have not been coming. In fact, we have enjoyed tremendous cooperation from the police in that regard, in terms of obeying the directives of the panel. I just don't want to go into details, but by the time you get our final report, we have cases in which, even without taking a decision, the police had gone ahead to remedy situations and given benefit back to complainants who appear before the panel. So I think that in that regard, I must commend the Nigerian police force.
Well, the question specifically is, in cases where the policemen don't appear, does that in any way affect the outcome? Will that in any way affect the outcome of that particular case? Now, the specific cases where the policemen don't attend.
Well, if there is any case where we summon a policeman and they do not appear, it does not affect our work at all. What we do is to listen to the complainants, listen to their witnesses. If, according to our law in Nigeria, an allegation is made, we give you opportunity to come and defend it. Once the opportunity is offered and you decline or you don't take advantage of it, we will go ahead to do the needful if we believe the story of the petitioner or the complainant and give our verdict as the case may be. So the absence of the police, the army, or any other security agency does not in any way hamper the work of the panel or in terms of taking any decision in that regard at all, sir.
One of the things that's raised this issue of judicial panels all over the nation is, at the core of it, is human rights. And one wonders, I mean, with that report of the U.S. Department of State that you referenced, one wonders if indeed, I mean, I'm pretty sure you have seen the report, what you make of it. That report juxtaposed with the true position of human rights in the country. What do you make of it?
Honestly, the American report on the state of human rights in Nigeria, you say, is an understatement. In terms of general abuse of the rights of the people, I mean, you just go around the entire country and do a spot check on places of detention, police stations, or even the prisons, and find the number of people who are in custody, you know, and are not being allowed to exercise their fundamental rights. So in that regard, I believe that it's not unique to this particular regime. Over the years, Nigerian government has been guilty of consistently denying the citizens their right of access to justice, right to freedom of movement, right to liberty. And so it's not just in year 2020 alone. I mean, look at the Amnesty report, for instance, where we're told that since the Boko Haram or the insurgency started in Nigeria, extrajudicial killing has been going on. You know, apart from the one being committed by the insurgents, the state agencies go ahead to execute people without an order of court. So in that regard, I do not fault the report of the American government in terms of violations of the rights of the people. My concern was just the isolated issue of what happened at the Lekki toll gate on October 20.
Well, still talking about the human rights thing, and you have underscored something critical in that it is not new, it's not peculiar to one particular government. It's something that's been happening for many, many years. You referenced your own experience as well. But we have spent 21 years in a democracy. What is hindering us or holding us back from doing the needful? You talk about a system. We've had quite a few governments within these past 21 years. So what is the problem with us getting the human rights end right?
Well, thank you very much. I think I can just answer this to say that part of the struggle for true federalism, for democracy and the rule of law in Nigeria is to ensure that the system that produces our leaders becomes transparent and can become something that will encourage genuine patriots to participate. Because look at my friend Mr. Yinka Dumakin, look at my friend Innocent Chukuma, look at my friend Bamidele Aturu, Imai Zazu. I think that the people who find themselves in government eventually do not know the history of where democracy comes from. So they are not able to appreciate the kind of struggle that people have put in to get to where we are. And so when they get there, they just see it as just leadership and opportunity to enrich themselves. And in that regard, they forget the basic tenets of democracy, which is good governance, which is respect for the rights of the people. So until we get our system so elevated to the level that honest and genuine patriots can aspire to positions of leadership, if we keep reproducing this set of leaders who will hand over to their children over the years, we will keep experiencing this thing almost till eternity. And that's the reason why it's painful that those who actually struggled and paid the price for democracy are not the ones in government. That is the gap that is leading to all the confusion that we have.
But doesn't that put a question mark on our systems generally, Mr. Ebonlu? Because, I mean, it's not the politicians that execute these things. It's the people who are working with governments, the civil servants and the rest of them, who are supposed to have a system of continuity, whichever person is elected into power.
Well, I mean, you can just, let's take two examples. There are two dominant political parties, All Progressive Congress, People's Democratic Party. If you check the history of litigation in Nigeria, in the past 4 years, we've recorded over 1,000 cases in terms of internal democracy of the parties themselves. How leaders impose, how leaders name themselves as godfathers. So until we get back to that same struggle whereby, as is happening in the political parties, we can dismantle this culture of godfatherism, of imposition, you can't just get anything done. It will just be, in 2023, we will still be singing the same songs, manipulation of results, and that takes us to the basic struggle of restructuring. Unless you dismantle this constitution, unless you take away all those sections that do not allow true federalism, we'll just be singing the same old songs every year. Unfortunately, though.
Okay. I mean, the dismantling of the Constitution must have, pushed the message home for a lot of people. But, for that report that was released by the U.S. Department of State, a lot of conclusions were drawn by different people. In fact, you had those celebrating it as a final verdict on what exactly played out at the Lekki toll gate. But going through that report, really, did it make any conclusion? Because all it said was, as though it was reporting all that had happened. So was there really any conclusion in that report?
No. As a matter of fact, first of all, is to note the limited scope of that report. It's for the year 2020. So probably must have ended in December. As of January 2021, the judicial panel is still taking testimonies from people who claim to be victims. We are still taking testimonies from doctors who claim to treat people. So if at all America wants to make any reference to what happened at the Lekki toll gate, it necessarily has to wait for the outcome of all these testimonies, all these evidences, for the panel to come out with a determination one way or the other. So in that regard, specifically, I think there was no conclusion in that report, and there couldn't have been any conclusion on it, because what the American government could have based its conclusion upon are all materials that are still before the panel. We empaneled an expert, they submitted reports. Those reports are still pending. We have not taken a decision. We have not even presented the expert report on the Lekki incident, because the CCTV was given to us. We played it. We gave it to our expert. And we are waiting that these experts will come before us and testify and be cross-examined before we then take a decision. Which is why I explained, for instance, that even in 1 year, it may be difficult to conclude that assignment. But we are determined to come to a conclusion as much as we can, in respect of Lekki toll gate in particular.
Which takes me to my next question. Would you be pushing for an elongation? Yes, it's been extended by 3 months, but if 1 year, 70 cases out of 230, I imagine how much time that the panel has. So is that something in the thinking of the panel, possibly further elongation of the tenure of the panel?
I believe that what we do is to assess the nature of work done, at a particular time, and maybe when we get towards the end of the extended 3 months, we'll be able to determine how far we have gone. Like I told you, we had 230 petitions. I don't imagine ever that a single petitioner will be denied the opportunity of hearing, but just because there is no time. So I think we still have the opportunity to interact with the government of Lagos State. If it becomes clear that we have not been able to exhaust even half of the timetable of the panel, surely we will not, on the altar of expediency or time, then denying Nigerians. Otherwise, the purpose of the panel will have been defeated if a single petitioner is not heard at all. So if we get to that stage in the next 3 months and we're unable to conclude, surely, there will be need for elongation, with all due respect.
Well, at the end of the panel sitting, what is expected to happen both at the state and at the federal level?
Well, as you can see from what we have done so far, there are remedies that are immediate. That is, if we find that maybe somebody has been killed extrajudicially without any explanation or without lawful excuse, and we have come to a verdict that it was wrong, we give a particular amount in terms of financial compensation, even though it could not bring back that life. We've given 10 million, we've given even more than that. So that already is achieved. The second thing is we then make recommendations on the handling of weapons and firearms. We then make recommendations for training for police and security officers. We make recommendations in terms of the need for education in the knowledge of basic human rights of the citizens for the law enforcement agencies. Because you will discover that even the police officers themselves may not be aware that you are not supposed to beat a suspect. You are not supposed to torture them. You're not supposed to compel a suspect to write a statement. if he insists that his lawyer should be there. So education is important, and those are part of our recommendations, that we give at the end of every verdict. So when we conclude, we then summarize them and pass it to the state government to be passed to the federal government for implementation. In Abuja, for instance, the National Human Rights have been able to collate its own petitions and come to a conclusion which has passed to the National Assembly. You remember that the Speaker of the House of Representatives, Honorable Femi Gbajabiamila, said that he was not going to sign the 2020 appropriation if there was no provision made for compensation for victims of police and other security abuses. So I believe that at the end of the case, in all the states and even at the National Human Rights, people will have cause to smile with all due respect.
Because, I mean, while the panel sitting goes on, just as you referenced in passing, daily, on a regular basis, in fact, on the streets, you still see citizens who are still being harassed by security agencies who perhaps oblivious of the essence of the panel itself. So to some extent, it just suggests as though, well, the panel can have their sitting, NSAS is over. It's back to business. So is this recommendation, are you optimistic that at the end of the day, what you mentioned being ingrained in some security agencies in terms of how they handle citizens, us and them scenario, will become history or will be addressed?
Thank you. I generally believe that cases of human rights abuses by security agencies is not limited to physical contact in terms of arrest, in terms of beating, torture, even assigning policemen to take over another person's land by force, assigning policemen to help you eject a tenant against the normal procedure of law. The abuses come in various grades. And that, it goes beyond the work of the panel, with all due respect to you, Chamberlain. Reforming the police, reforming the security agencies is something that is deep-rooted. It's something that the National Assembly has to be involved, the stakeholders, at our own level at the panel. We can best do these recommendations to ensure that we minimize, the occurrences of these abuses by making recommendations for education, for reform, for funding. But in terms of the daily occurrences, I do not want to deceive myself to say they will cease immediately. It will probably take time for these things to come to pass.
Well, who knows? Does that suggest it may take another kind of protest? Or maybe the system may just think, let's implement some of these recommendations. Is that what you think?
I think the police itself and the other security agencies have learned some lessons from the NSAS protests in terms of the power of the people. Because it got to a state when nobody was in control. Yeah. And we don't want to see that again. And so it behoves on the police to embark upon self-examination and be able to extend some kind of self-restraint in terms of the exercise of force on the citizens of Nigeria. The word Nigeria Police Force, as inherited from the colonialists, should no longer be the mentality of the regular police, whereby you use your uniform or your weapon to get what you want at the expense of the rights of the citizens. It will take some time, but I believe gradually we will get there.
All right, a good place to leave it on that optimistic note. Mr. Ebonlu Adegborowa, Senior Advocate of Nigeria, thank you for your time this morning.
Thank you very much.
We're back in a moment. Don't go away.